DSPS board member training on ethics and lobbying for state public officials. I am Rene Parton. If you haven't met me, I am the Assistant Deputy Chief Legal Counsel for DSPS, and I provide legal advice to our boards as the supervisor for our board councils and the administrative rules coordinators. For our training today, this is meant for our board members who are nominated by the governor and approved by the Senate through what we call the confirmation process. This will be helpful for our new board members, but also a great refresher for us all. Today, our presenter is David Buerger, who is a staff counsel at the Wisconsin Ethics Commission. David has been staff counsel at the Ethics Commission since it was created in 2016. Prior to the Ethics Commission, he was staff counsel for the Government Accountability Board and worked on the elections division as an election specialist. He went to Marquette Law School and was formerly the court commissioner in Oneida and Vilas counties. I'm going to turn this over to David. Thank you, David.
Thank you. Okay, first off, thank you for the invitation to speak with you all today. Very much appreciate the opportunity, whenever possible, to go out and speak with our state public officials. Today, we're going to walk through the ethics and the lobbying laws. This is obviously much more complicated than our presentation will permit. So today's goal is not to have you walk away knowing every nuance of these laws, but rather to start flagging some issues for you so that you can leave today's presentation knowing when a particular situation that you may run into with your board or commission or council might be something you need to talk to your agency legal counsel about, talk to the ethics commission about. It's really just to give you that first level of knowledge, that comfort with the ethics and lobbying laws, so that you can know where you're on firm ground and where you want to talk to someone, maybe get some advice. So with that in mind, we'll get started. I always like to start our presentations with a little bit of history. I've got a political cartoon up here from 1858. Those of you who know your Wisconsin history know that this is very early on in the state's, in our statehood. We're on our fifth governor, Governor Coles Bashford. And as you can guess from the political cartoon here, we were going through a bit of a scandal. Governor Bashford did something, well, it would probably still be extraordinary today. He served one term as governor, and then he declined, even though his party wanted him to run again, he declined renomination for governor and instead ended his term in office after that one term. There had always been some rumors swirling about the Capitol that there had been some bribery going on during Governor Bashford's term. So there was an investigation launched, and it turned out, yeah, there was evidence that there had been a bit of bribery going on in this. As you may know, again, 1858, you're looking at railroads. They're the big companies of the era, and they were offering bribes to officials all across the state government, not just the governor. But what the investigation turned out was that Governor Bashford himself personally had received the largest payoff in about $50,000 worth of stock and $15,000 worth of cash from the railroad company, the La Crosse Milwaukee Railroad Company. And you might think, well, 65,000, that doesn't seem like a huge amount. But if you extrapolate it forward into today's money, that was about $1.5 million that he had received in payoffs. And like I said, other members of his administration, some legislators, and even a Supreme Court justice were also found to have accepted bribes. Those totaled $400,000 altogether, which is about 9.7 million in today's money. So it was quite a significant scandal right at the beginning of our statehood. And as you can guess, whenever there is some sort of scandal, there typically tends to be a reaction in the form of a reform or regulatory effort. And that's what happened here. Wisconsin started regulating lobbying after this incident. We were the second state to do so in the entire union. And the Code of Ethics for Public Officials followed shortly thereafter. And we've been adding to that over the years. And it's been recodified a number of times, probably most recently in the 1970s with the Watergate scandal. So that's kind of leading us to where we are today. A little bit about the Ethics Commission. We do have a partisan appointment structure. So we've got two former judges on our commission. I really appreciate having those professionally trained and experienced decision makers. Those really do help us navigate the statutes. We also have 4 other political appointees, and they're all on 5-year terms. Even though there's a partisan appointment structure, I think it's important to note that bipartisan cooperation is built into the system. Every action of the commission requires at least 4 votes, which means you can never have a strictly partisan decision of the commission. You're always going to have at least 3 members of one side and 1 of the other. So if it was strictly a partisan issue, it would deadlock 3-3, and there would be no action of the commission. Also, even though we have a bipartisan appointment structure for our commission, I would note that all the staff are nonpartisan. We're required by law to be nonpartisan, so that's myself as the staff counsel, our administrator, and the rest of our staff. And we are a pretty small staff, but we do a lot with a little. Also with our staff, one of the things that we try to do with the nonpartisanship is it's there so that everyone can feel comfortable contacting us, and going hand in hand with that is our confidentiality policies. That's not just a policy, it's also a criminal penalty if we breach that confidentiality. And so I would assure you all that we take that very, very seriously. No one on our staff wants to face a $10,000 fine or 9 months in jail. So rest assured, if you contact us, you're seeking advice, you're seeking guidance on how to proceed in a particular matter, we are not going to repeat that to anyone. We keep that strictly confidential. Also, that applies to the public records law as well. We've got exceptions within the public records law that specifically apply to our complaints and our requests for advice. So if something comes before the commission in those contexts, you don't have to worry about it coming out through public records requests or, like I said, through our staff talking to anyone. That applies to both our staff and to our commissioners. We deal with all these things in closed session, and we keep them in strict confidence. Last bit on the history is just as you're going through the various ethics board or the various ethics opinions that you may see during today's presentation, you'll note that there's going to be a bunch of different names. So back in the 70s, the regulating agencies were a state elections board and a state ethics board. The elections board had campaign finance and elections, and the ethics board had the code of ethics and the lobbying law. Those all got mushed together into the Government Accountability Board in 2007. When the Government Accountability Board went away in 2016, though, they got split into the present commissions, the elections and ethics commissions. Elections only retained the elections duties, though. So campaign finance came over to the ethics commission. So we've got campaign finance, we've got the lobbying laws, and we also have the code of ethics. So a large part of what the commission does at present, we administer and enforce these 3 areas of law. We conduct programs just like today to explain and interpret these laws, and then we compile that information and make it public. That's really a large part of our job too, is not just that everything's being filed with us, be it campaign finance reports or financial disclosure forms. We want to turn around and make that information available to the public. That's what furthers our mission to promote confidence in Wisconsin government, so that everyone can go to our website, contact the commission, see that government officials are not acting in areas where they have a special interest. And we'll talk more about that a little bit later. With our jurisdiction, we have, under the law, we've got co-equal jurisdiction with Wisconsin's district attorneys for enforcement. Typically how that's played out, though, is that the Ethics Commission focuses primarily on the state level. So we will administer and enforce the Code of Ethics as to legislators, the governor, executive branch officials, judges and justices. We also take care of the lobbying law, so we have all the lobbyists and the lobbying principals. And most campaign finance registrants, so most of your PACs, independent expenditure committees, candidate committees, the political parties, those are all under our purview. District attorneys typically focus on ethics violations at the local level. So if there is a particular ethics issue, maybe with a alderperson, a mayor, county executive, or county supervisor, those sorts of things, will typically be handled by the local district attorney. It's not to say that the Ethics Commission isn't involved in those decisions, but we typically defer to DAs, to police in their own jurisdictions. Also, DAs do typically be a little bit more involved with their campaign finance of local candidates and local referendum committees. That's going to change. You may know there's a bill in the legislature right now, actually, that will have campaign finance reports filed with the state for everyone. So It was originally going to be this summer. There's a bill in the legislature that's going to move that out a couple of years, so it'll not be until December of, I believe it's 28. Don't quote me on that, but it's going to push it out a couple of years. But that's kind of the breakdown we have right now, is that most things, at least at the state level, are handled by the Ethics Commission. So like I said at the beginning, we're going to go through the lobbying law today. We're going to talk about, there's one primary prohibition in the lobbying law that limits what you can accept from lobbyists or lobbying principals. We'll talk about that in a little bit of detail. And then we're going to spend the majority of our time on the Code of Ethics. And as you can see, there's a bunch of different provisions in the Code of Ethics. There's prohibitions on the use of your office, what you can accept, food, drink, transportation, lodging. There's restrictions on that. Use of confidential information is an important point. And then we'll talk also about unlawful benefits, conflicts of interest, and the financial disclosure. So with that, we'll get into the lobbying law. So lobbying laws try to draw a black and white line between people who are paid to influence legislation or administrative action, those that being lobbyists, and the individuals that hire those lobbyists, the lobbying principals, and the people making those decisions. And at times, it's been more or less successful. So as you can see from this political cartoon again, there was a report a number of years ago that revealed that legislators were relying on lobbyists, who they sometimes referred to as angels, because they would take care of them in various ways, typically gifts or taking them out to dinner, that sort of thing. So while your boards and commissions may not be wined and dined as much as a legislator would, I still encourage people to be mindful that there may be people out in the community that are aware of your official role, may have an interest in how you're deciding things, what actions are going on at your boards and commissions, and they might make you offers that you may not have received before. So you just want to be very mindful of the fact that you're holding a state public position now, and there may be individuals that have a vested interest in trying to influence your decision making. So the first question that always comes up is, who does this law actually apply to? So we've got a Wisconsin lobbying registry. It's lobbying.wi.gov, and you can go there and you can search for the names of lobbyists. You can search for the names of lobbying principals. Again, those are the organizations that employ lobbyists. You can search by keywords. You can try to find out, who are the lobbyists and who are the lobbying principals that may have an interest in my particular area, so you can be more mindful in your interactions with them. Because the lobbying law, as I mentioned, it's probably the strictest black and white laws that we have in our areas of regulation. Generally speaking, if an individual is a lobbyist and the recipient is a covered public official, there's not really that many exceptions that apply. You're just not allowed to receive things from that person. So you want to know who these people are in advance. The lobbying website does have a way for you to download directories. I don't know that too many people are necessarily making use of that nowadays. Everything's electronic, but if you want to download a directory, you can get it in PDF, you can get it in Excel, whatever works best for you. I know downloading an Excel can be particularly useful if you're going to send out some sort of solicitation or communication. It kind of gives you a way to filter out people who may be lobbyists or lobbying principals from your mailing list. So that's one useful function I'm aware of. Also, the lobbying website also has a way for you to track lobbying. So if your commission or board has a particular matter moving through the legislature, maybe it's a bill, maybe it's an administrative rule, something like that, you can track any sort of lobbying activity on those bills or on those rules. You can see who's registering for, who's registering against, what sort of activity is going on with those rules, and that can kind of keep you in tune with who's lobbying and who are they talking to, what are they saying. Now, for the purpose of today's presentation, I'm going to assume that everyone here is an agency official, but just briefly to cover the definition here, an agency official is a member of an agency, officer, employee, consultant, etc., who as part of their official responsibilities participates in administrative action in other than a clerical capacity. So they've got some sort of discretion that they exercise. It's important to note that this does cover people with official responsibilities for administrative action. So even if you personally have not involved yourself in an administrative action, and when I say administrative action, I'm talking about the administrative rulemaking process. Even if your agency hasn't necessarily done anything in the rulemaking realm, if you have official responsibilities for that, so you could potentially take action on administrative rulemaking, you are considered an agency official. But there's some variations in that. There's some detail, certainly. If you're not sure, please check with your agency counsel. They can explain to you whether you are or you aren't covered. But again, for today's purposes, I'm just going to assume everyone here is an agency official. And again, with administrative action, that's the rulemaking process, but I also want you to take a pretty broad view of that because administrative action includes things like recommendations or proposals or consideration. So even if your agency or your board does not necessarily have the ultimate authority to promulgate the rule, if you're proposing things or you're recommending things to some other agency, and that agency will subsequently take that and turn it into a rule, then you are probably engaged in administrative action as well. All right, so assuming that you're covered, what does the lobbying law prohibit? It says that no lobbyist or lobbying principal can give to a covered official lodging, transportation, food, meals, or beverage, money, or any other thing of pecuniary value. So you can see how this is a very broad prohibition, and it's largely black and white. If they're a lobbyist or a lobbying principal and you're a covered official, these things essentially should not be trading hands. Now, of course, there are exceptions, and we'll get into that in a little bit, but I want to impress upon you all that this is pretty black and white, and it is a pretty strong prohibition. We call Wisconsin a no cup of coffee state because in theory, you can't even accept a cup of coffee from a lobbyist or a lobbying principal because that would be food, meals, beverage, money, or any other thing of pecuniary value. And again, pecuniary value, we're talking money. It's kind of, we're using synonymous terms here, but the idea is that if you're paying money for it, you should not be able to accept it from a lobbyist or a lobbying principal. So with that, let's talk about the exceptions. First one, we do want you as a public official to still be able to talk to your regulated community, talk to the public. So one of the exceptions is for actual and reasonable expenses when you are presenting a talk or participating in a meeting. So if a regulated organization wants to have you come talk to their members or something like that, they have some sort of conference or meeting, they can pay to bring you out there. They can pay for your travel expenses. They can pay for a hotel. They can pay for food and beverage while you're there, that sort of thing. So again, this is in order to encourage you to go out and talk to the public about the business of your agency. Also, the admission to events to discuss your agency. So maybe there's not anything that's going to necessarily trade hands as far as transportation, lodging, food, or beverage, but there's some sort of admission cost otherwise to attend an event. You can accept admission to the event as long as you're there to discuss the official business of your agency. Please note that in this context, it does not include food, beverage, etc., unless you pay for that, pay the actual cost. So there's a bit of a line here. So these are typically things that are more social in nature. They're kind of discussing the business of the agency, but you would not be accepting the food and beverage again without payment of the actual cost. That's contrasted with where you're actually presenting a talk or participating in a meeting. That's where you are more on the agenda. You're addressing a full audience. In those sorts of things, you can accept those actual and reasonable expenses, including food, beverage, etc. Items and services made available to the general public are also allowable. You'll see a lot of times these lobbyists, or I'm sorry, these lobbying principals are large organizations. They are, powerful business interests, et cetera. And so they're going to be dealing with the general public in their capacity as a business. And so they may have offers that are open to the public, and you as a covered official can still partake in those offers. You can accept those offers on the same terms as a member of the general public. Examples I've seen in the past, things like banks that may be registered as lobbying principals. They have offers that if you open an account with the bank, keep it open for a certain number of months or have a certain balance for a certain period of time, and they'll give you $100 or something like that. That is an offer where you would be receiving something of value from a lobbying principal, but because it's an offer that is open to the general public, you can participate on the same terms. Other things that are allowed from lobbyists and lobbying principals are educational and informational materials. A large part of what lobbyists and lobbying principals are doing is they're trying to persuade, advocate for their particular client's interests, and they'll do so through providing informational or educational material. That's fine. Where the line here is that it does have to be materials. So this would not necessarily cover, going to a business site in Vegas or something like that, or a conference in Vegas. Now, there's other exceptions we'll talk about later that might allow you to accept some travel, but this exception is limited to the actual physical materials. So books, videos, that sort of thing. One other exception that I really wanted to highlight for you all because of your roles on boards and commissions is that there is an exception in the lobbying law that allows you to accept compensation if you're an employee of a lobbying principal and you're only an agency official because of your membership on that commission, board, or council, and you're not receiving compensation from the state other than a per diem or a reimbursement for your expenses for state service. So I know a lot of members of our boards and councils here in the state, they require membership of the regulated community. So they're going to have people that are otherwise regulated by the board. They're going to be on the board in their role. And so in those situations, say you are an employee of a lobbying principal, you could still accept compensation from that lobbying principal during your service as a state public official. The real line here is that the compensation that you're being paid by the lobbying principal shouldn't change as a result of you serving on the board, commission, or council. So if you accept a position on a board, commission, or council, the lobbying principal shouldn't be dramatically changing your compensation because of that. Generally, we look to other similarly situated individuals. Are they being paid the same amount or roughly the same amount? So it's a very fact-intensive inquiry. But just to let you know, if you are working for a lobbying principal, you don't have to quit your job. You can continue to receive compensation as long as you don't have that compensation dramatically change because of your official position. Also, I want to note that the lobbying law is very nuanced. There are a lot of other exceptions that I'm not talking about today because they're very corner case, they're very specific. So generally speaking, if you are in a situation where you are potentially receiving something of value from a lobbyist or a lobbying principal, that's probably where you want to check with your agency counsel. Because it's so black and white and there are very strict, narrowed exceptions, you really want to make sure you're in the right of it before you accept anything from a lobbyist and a lobbying principal. It's not one of those things where you kind of work it out after the fact. You really want to make sure you're on solid ground before you go in. And again, that's the reason why we want you to go to the lobbying website, find out who are the lobbyists or the lobbying principals, be aware of that so that, if you take a meeting with somebody, that somebody offers you something, that you can say, oh, okay, in this particular situation, I need to check with my agency counsel to make sure I've got that exception to the lobbying law so I can accept. One other exception that's important to note is campaign contributions. So lobbyists, a lot of times are also involved in the campaigning space. They'll be administrators or they'll otherwise participate in the activities of political action committees, that's PACs or other campaign finance entities. So what the lobbying law does is it prohibits a lobbyist or a lobbying principal from giving anything to a covered official out of their own pocket, but they can still deliver contributions from others. So they can deliver a contribution from a PAC. So you'll see a lot of times a covered industry, a regulated industry will have its own PAC. And so that PAC will collect contributions from the individuals that work in that industry, and then it gives those contributions. And a lobbyist, as an administrator or other member of that PAC, they can still deliver those contributions because they're delivering PAC contributions. They're not giving out of their own personal funds. However, lobbyists can make a personal contribution as well during a certain window. That's the first day to circulate nomination papers through the day of the election. Also for legislative offices, it's further limited by whether or not the legislature has concluded its final floor period. So just know, again, when it's in the campaign finance context, generally speaking, it's restricted, but they may be, a lobbyist may be wearing a different hat. They may be working as a member of a PAC. And so in that context, they could give a contribution. I should say the PAC can give the contribution. So yeah, campaign finance law is, again, more than we have time to cover in today's presentation. So I'll just leave it at that. Again, if you have questions, feel free to contact the commission. All right, so then we'll move into the Code of Ethics. We'll spend the rest of our time here focusing on the various restrictions within the Code of Ethics and hopefully leave a little bit of time at the end for some questions. First off, who does the Code of Ethics apply to? Well, again, I'm going to assume everyone here is a covered official, but just to be clear, that the Code of Ethics applies to all individuals who hold state public office. That's the governor on down. Everyone's playing by the same rules. It goes down essentially through a state agency all the way down to division administrators. That's typically the cutoff. But some agencies will have what they call division administrator equivalents. And so sometimes it tends to reach other people who are not actually labeled division administrators. But generally speaking, and I heard this at the top of the presentation, if you are appointed by the governor, you're confirmed by the Senate, you're a covered official. You're holding a state public office. Other definitions that are important to note as we move through the Code of Ethics, immediate family. Immediate family is not what you might think just from the dictionary. Immediate family is specifically defined in the Ethics Code to only include an individual's spouse or an individual's relative by marriage, lineal descent, or adoption who is receiving more than 50% of their financial support from the official, or vice versa, where the official is receiving more than 50% of their financial support from whoever this relative is. So it doesn't cover things like adult children that have their own household, extended family, aunts, uncles, etc. It's just those individuals who are providing financial support or receiving financial support of 50% or more from the official or to the official. Otherwise, it's just the spouse. Associated, you'll see this used in the Code of Ethics to apply to organizations, whether you're associated with an organization or not. And when we say associated, again, it has a very specific definition. In order to be associated with an organization, you have to be a director, officer, or trustee of the organization. So you have to have that leadership or control. You have to have, alternatively, you could own or control at least 10% of the organization's outstanding equity. Or you can be an authorized representative or agent. And that's usually pretty specific. Things like lawyers or other individuals that, in their professional capacity, they're authorized by an organization to represent them or to serve as their agent, then they would be considered associated with that organization. But note that associated does not apply simply on the basis of employment. So if you're employed by an organization, unless you've got that ownership stake of at least 10% or you're in the leadership of the organization, generally speaking, you are not considered associated. That's not to say that it might not create the appearance of impropriety or bias. So when you're dealing with situations that affect your employer or perhaps the employer of a spouse or something like that, it certainly makes sense. You may want to be cautious to avoid that appearance of impropriety. But under the Code of Ethics, technically, you are not associated with that organization. Also with organizations, the definition does not include bodies politic. So some of you may be elected officials on the local level or possibly on the state level as well. In these situations, you don't have to worry about how your actions on your board, commissioner, council are going to affect a county or a municipality. So say, maybe you're in a position where you're talking about reallocating resources, maybe certain areas of the state are going to benefit more or less based on how you decide a matter. You don't have to worry about a conflict of interest when it deals with a conflict between two public bodies. When the Code of Ethics is referring to organizations, we're really talking about private organizations, not those that are created by government. Also, anything of value, this is what we use to kind of describe what's prohibited in the Code of Ethics. And like you saw before with the lobbying law, it is pretty broad. It includes money, property, favors, services, promises, but it does not include compensation paid by the state, political contributions like we mentioned before, or hospitality extended for a purpose unrelated to state business by a person other than an organization. So typically that's your, I went to dinner with a friend at their house. I can accept a beverage at their house. I can accept a meal. Those things are being provided to me not because of my state office, but because of the pre-existing friendship or whatever it is. So uh, we'll talk about the exceptions later. The exceptions would also cover that situation, but just to be clear, when we're talking about anything of value, it already specifically excludes hospitality at an individual's home. All right, prohibitions in the Code of Ethics. First one right off the bat is that no state public official can use their public position or office to obtain financial gain or anything of substantial value for the private benefit of him or herself, his or her immediate family, or an organization with which he or she is associated. So you can see how all those definitions we were just talking about all come together here. Uses of office. So typically that's going to be when someone offers you something because of holding your public position, or maybe you're using your public position to obtain something, seeking out or soliciting something. That would also be a use of office. So also it's important to note the use of office to obtain financial gain includes use of office to avoid a financial loss. So anytime you've got a financial interest individually in a matter, that's probably a good indication that you're not going to be able to participate because of this prohibition on use of office for private gain. But there are a couple of exceptions here. Two that I'll just note right off the bat is campaign contributions again. Those are commonly accepted in the law. And then a candidate, and it's important to note here that candidate includes both incumbent elected officials as well as those that are, the more literal definition of candidate, they're seeking election to that office. They have a special exception that allows them to solicit for donations to nonprofits that they are associated with. So normally you would not be able to solicit donations to a nonprofit that you're associated with. Again, associated being like you're in the leadership of that organization. But political candidates do have the special exception where they can still solicit donations for nonprofits. Not to say that they can be using their official resources to do that solicitation, but they can reference their title, things like that. All right, so I try to always give examples of how these things play out from history so as not to embarrass anyone. This example is from the 1990s, which doesn't feel that long ago, but here it is. So this official, basically his wife had a travel agency, and he had directed purchases of his travel for his organization through that travel agency. That's not to say that there was any misappropriation of state funds per se. I believe the facts were that it was the market rate. He was paying market rate for the airline tickets. He was paying the regular rate for the hotel rooms, et cetera. So it wasn't that. It was that his wife was getting a commission for all of these sales. And so by directing the agency purchase his travel through his wife's travel agency, he was benefiting his wife. And as we noted in the prohibitions, that would be a use of office to benefit your immediate family, i.e. the spouse. So it was prohibited, and this official ended up paying a $150 fine. So this is the sort of thing that can come up if you are potentially self-dealing, especially with your spouse, but it's probably a good thing to keep in mind whenever you're dealing with associated organizations, is that you want to be very careful that in your official capacity, you're not steering any projects towards organizations with which you are associated, because if they financially benefit from it and you are associated, that is a violation of the Code of Ethics. Another way this commonly comes up is tickets. So a lot of times you'll see situations, or we see situations where an official will get invited to a sporting event or a concert, something like that. Maybe there's particularly good seats or a skybox involved, some sort of premium seating area. And the question is, can I accept this ticket? Our general rule is that you always avoid accepting anything from a lobbyist or a lobbying principal, even if you were going to pay them for it. That doesn't get you out of prohibitions under the lobbying law generally. So if it's a lobbyist or a lobbying principal, you want to be as certain as you can that there's a specific exception that allows you to accept. If there's not, best advice is to steer clear. Let's take, so if it was a lobbyist or a lobbying principal that was offering the tickets, probably best to decline, unless you're sure about that exception. If it's not a lobbyist or a lobbying principal, then the next line is you shouldn't accept anything of more than trivial value if it's offered because of your position. So this is what we were talking about before. If you are appointed to a board, all of a sudden you're getting offers to attend events that you weren't being invited to before. People are asking you to, attend, saying that, it's free admission, they'll pay your way, that sort of thing. You probably don't want to accept those things either, because they're being offered because of your position. Like I said, there are exceptions, but that's the next line we look to. If it is offered for reasons unrelated to your public office, again, we've got, the friend scenario, friend from, many years ago, you've kept in touch, you commonly get together. That's something where, yeah, you could probably accept something from a friend, even if it's tickets, even if it's skybox, as long as it is, again, unrelated to your public office. If there was some sort of offer that was open to the public on the same terms, you could always accept that. So if there's, admission with, some sort of donation or something like that, or there's a special area that's open if you, apply in advance and you get picked as a lottery kind of winner of an event or something like that. As long as you're participating on the same terms as the general public, that's fine. There's no benefit to you because of your state position. But one thing that we always want to caution people with gifts is that if you are accepting something, you have to disclose the identity of the person who gave you the gift. So not the gift itself, you're not disclosing that, you're disclosing the gift giver. If they give you at least $50 or more of value in a calendar year. So two things to highlight here. One, this is an aggregate tracking. So maybe somebody buys you lunch and the lunch itself is not going to be more than $50, but then 3 months later, they take you out to lunch again. And 3 months later, they take you out to lunch again. That sort of thing in aggregate over the calendar year will probably amount to more than $50. And so you will have to disclose the identity of that person, even though no individual gift was more than $50. So just be wary of that. As things inflate in price, it's kind of harder and harder to avoid listing people if you're receiving anything from them at all, because in the aggregate, it's going to add up. The other thing is just be careful about face value versus true value. The ethics code requires disclosure of gift givers based on the actual value of the gift. So if somebody gives you a ticket and maybe the printed value on the ticket is $20, but you look it up on StubHub or something like that, and it's actually a much harder get than, you had to have like a special friend or connection in order to get the ticket. That's something where you probably want to look and see what's the actual market value of the ticket, and don't just rely on the printed value. That can commonly catch people as well. You want to be very cautious about printed value on a ticket versus the true value. Now, say you get a gift and you're not allowed to keep it. Well, in that scenario, it used to be just guidance of the commission. Now it's actually in state law. There's a variety of different ways you can dispose of a gift that you've received that you are not allowed to accept. First option, give it to your official agency to use or to sell. It's important to note that when we say sell, the agency cannot then sell the item back to that government official or employee. So that's one option if it is something that the agency could use. If it's not something the agency could use, but might still have some utility to a public institution or another state agency, you can give it to them. You can also give it to charity. When we say give it to charity, though, you want to be cautious you're not giving it to one with which you're associated again, or their immediate family is associated. We want to avoid any appearance of impropriety, of course. And then The fourth option here is to return the item to the donor. This is not a popular option. It's probably considered impolite in some circles to return a gift. In these circumstances, I do encourage you, feel free to use the Ethics Commission as the bad guy. We're the mean parent. We're not going to let you keep these things. So you can commonly send them a letter with the gift that you received and say, I checked with the Ethics Commission, or I reviewed the Ethics Commission's guidance in this matter, and unfortunately, I can't accept this. My regrets. I'm returning it. The last one, and I don't encourage this one particularly, but it is in state law, so it's a little bit stronger than it used to be. If the donor is not a lobbyist or a lobbying principal, there is an option to purchase the item and retain it. Again, this only works in the context where the lobbying law does not apply, and it should only really be used in situations where there is a clear market value. So some organizations that may want to give gifts, it may be very clear what the value of the gift is, something like a t-shirt or a hat that the organization might sell on their website. If you're like, hey, I could purchase this online for $10 and they gave it to me and I want to keep it, you can pay the $10 to the organization and you can retain it. All right, the next prohibition in the Code of Ethics is on influence and reward. And this is a very fact-intensive inquiry. What it says is that a person can't give, and a state public official cannot solicit or accept anything from any person that could reasonably be expected to influence their official actions, votes, or judgment, or if it could reasonably be considered a reward for any action or inaction by that official. So it's really trying to get at, would there be a damage to the confidence in state government if this person was receiving this gift or was accepting this gift? As a general rule, we really encourage officials not to accept anything of more than nominal value when it's an organization that has a special or specific interest before your board, agency, or commission. We just want to avoid that appearance of impropriety. We want to avoid the corrosive effect it can have on the perception of state government that these people are receiving things from the people they're regulating. How could they possibly be unbiased? One thing that comes up fairly often, and I do want to address though in more detail, is the idea of awards. Commonly, a lot of you are going to be regulating various professions. You may be a member of that profession. They may offer you an award, lifetime achievement, man or woman of the year, that sort of thing, practitioner of the year, that sort of thing. The commission and its predecessors really have a long line of precedent that say, in the context of awards, if the award itself is made of unremarkable material, so like wood, plastic, etc., and it's an inscribed award, so it's got your name on it, a year, something like that, those generally have no pecuniary value because you can't really easily resell those. There's no merchantable value there. While an award may always have some intangible or prestige value, those sorts of intangible benefits have not typically been considered to be something that would trigger this particular provision of the Code of Ethics. We're really looking at more of those direct and demonstrable financial benefits that you would be getting from such an award. So one thing I can point to in the past that was not permitted, there was an official who received, I think it was a crystal vase or bowl, something of that nature, very well made, exceptionally valuable. I want to say it was in like $500 plus range. And the bowl or the vase, it rested on an inscribed base. So the base was inscribed with the official's name, but the bowl or the vase, you could remove it and it could be used or displayed separately. So in that context, I believe it was the Government Accountability Board said, that's crossing the line because that official could take that item off of the inscribed base, could sell it for a significant sum, and so that is probably something that would be prohibited. All right, another example that we use is teaching a seminar. A lot of you, like I said, maybe in various professions, maybe at the tops of those professions, you may be invited by a college or university to teach. Is that something you're allowed to do? And specifically, can you be paid to teach while you're holding a state public office? So again, the state law and the precedent of the commission has always been, we want you to go out there. We want you to talk to members of the public. We want you to go to meetings and gatherings to talk about the business of your agency. So we don't want to stand in the way of that. You may receive for teaching reasonable compensation as long as the material you're teaching is not prepared or presented with more than incidental reliance on state resources. So you can't get paid for something that was essentially prepared on state time or with the use of state resources. Also, this doesn't apply to lobbyists or lobbying principals unless some other exception applies. Yes, a number of universities and colleges across Wisconsin are registered lobbyists, or I should say they're lobbying principals. So you always want to be careful of that, because even though normally you would be able to teach and receive payment for teaching, if it is a lobbying principal that's doing it, you're going to have to find a different exception that applies in order to accept the compensation. Also, compensation, want to be clear, it can include things other than money. So maybe you're teaching and it's a very low monetary value that they're offering, but maybe they offer a variety of benefits like tickets to sporting events, entertainment, or reimbursement for travel, etc., including you or a spouse. Those things are all considered part of your compensation. And if you are receiving compensation, you have to disclose it if it's $1,000 or more in a calendar year. So this kind of goes back to knowing what you're accepting, knowing what the actual value is that you're receiving. Another prohibition in the Code of Ethics is on receiving food, beverage, travel, or lodging. This one's a pretty broad prohibition, but again, there's a lot of exceptions that can provide the easy outs. So again, official talk or meeting, things that are unrelated to holding public office. Again, the dinner and drinks with a friend. State benefit. This one comes up often in the context of educational events. So say there is a seminar or a conference that affects the regulated industry, and you want to attend because you're in that industry, you're a professional in that industry, and they're offering, well, we'll pay for you to come to this conference and learn about the industry. That's something where you're going to want to talk to your agency counsel, because there may be a state benefit in you being more educated and informed as to the issues that are affecting that regulated industry. And so we want you to go there and learn about these things. There may be a benefit to you, but there's also a benefit to the state. And if there's primarily a benefit to the state by your attendance, it is something you can accept under this exception. Political contributions, again, we talked about before, and then also WEDC and tourism have their own exceptions. Sometimes you'll be invited to events, it's going to affect a particular area of the state, either tourism or economic development. And those agencies have their own exceptions that allow them to solicit items of value and then give them to covered officials, even though you normally wouldn't be able to do that. So for more information on what you can accept, there's a guideline on the Commission's website. It's guideline 1211. I encourage you to review that one. It really walks through various scenarios where you're accepting something and who you can accept from and in what context. Use of confidential information. I don't know how much this will apply to all of you, but say there is confidential information that is being discussed by your board or agency. It's important to know that you cannot use that information or disclose it to benefit yourself, your immediate family, or this one, a little bit broader, any other person. So if the information has not been communicated to the public or it's not public information, you really do need to keep that to yourself. Disclosing it to any person in a way that would allow them to benefit from that information would be considered a violation. So this is essentially the equivalent of insider trading. If you have inside knowledge, confidential knowledge of, say, a particular chemical may be regulated, or a particular agency or a particular organization is going to get a contract for a particular thing, you're not allowed to trade on that information. You're not allowed your immediate family to trade on that information, or any other person, even like your next door neighbor. Unlawful benefit, as the slide kind of shows you, this can cover a variety of things, but most commonly we see it show up in the context of somebody gets pulled over and they try to pull out the, oh, don't you know who I am? or officer, can't you give me a break? I'm so and so. Those sorts of pleas for discretion on behalf of law enforcement, that's generally seen as an unlawful use of office or a use of office to obtain an unlawful benefit. So that applies to both you personally as well as for others. So you can't be making calls on behalf of other individuals, trying to essentially throw your weight around to try to get them some sort of special, again, unlawful treatment. All right, conflicts of interest. Conflicts of interest has two different prongs in our statutes. The first one, well, I should let me jump to the second one first. The second one kind of runs parallel to the code of ethics that we talked about earlier, and that it prohibits you from using your office to assist in the production of a substantial benefit, a little bit different term than anything of value, but a substantial benefit, direct or indirect, for yourself, a member of your immediate family, or an organization with which you're associated. So that does run pretty close to the other ethics code prohibition, but it's important to note that it does talk about substantial benefits, which could be different than anything of value. So even though you might be able to accept something, if it's something that's is considered a substantial benefit, but maybe not anything of value, it could still be prohibited under this conflict of interest prohibition. Going back to the first element, though, this law would prohibit you from taking official action in any matter that would substantially affect yourself, your family, or an organization with which you're associated, where that person has a substantial financial interest. So again, if it's something that is going to have some sort of financial impact, the difference between substantial and nominal is pretty hard to ferret out. But if it's got that financial aspect to it and it's affecting yourself, your family, or an organization with which you're associated, that's where you need to be cautious. Now, of course, conflicts of interest are fairly common, so we want to be cautious about how we apply this. The legislature has directed that the Code of Ethics is not supposed to prohibit a state public official from engaging in employment or following any other lawful pursuit, as long as it doesn't interfere with their full and faithful discharge of their duties to the state. So we want people from the community and from society, and again, from regulated professions, to be able to serve on these boards and not give up all their personal or economic interests. That's not what the law requires. You retain those rights of a personal and economic nature, but we simply expect that while you're serving on a board, commission, or council, that you're going to be making your decisions not just based on your own personal interest, but on the interests of the entire community, the state as a whole. So while you still need to engage in those employment activities, those professional activities, support your family and yourself, we know that you still have to continue in your professional capacities as well. So the code of ethics and the conflicts of interest laws are not supposed to prohibit you from taking action in those contexts. And the way we kind of draw that line, how both this commission and its predecessors have drawn that line, is we say an official may act as long as the action, so even if you've got a conflict of interest, even if it would be something that would affect you personally or would affect your family or your business, you can still act as long as the official action would affect a whole class of similarly situated interests, and the interests that are personal to you, either individually, your family, or your organization, are not significant when compared to the total interests affected, and the action's effect does not treat you any differently, disproportionately, I should say, than anyone else in the class. So it doesn't affect you to a greater degree or a lesser degree than anybody else. You're being treated the same. In that context, if all three of those elements are met, generally speaking, you can still participate. Common example at the legislative level is taxes. The legislature wants to make a change to tax law. It's going to affect everyone in the state, income tax or something like that. Then they can still participate because they're affecting a whole class of interests, everyone in the state, every taxpayer. Their interests are not significant when compared to all the taxpayers, and they're not being treated any differently, any lesser, any greater benefit or lesser cost, however you want to frame it. It's not being treated any differently. So generally speaking, though, in those contexts, it would be permissible. But this is definitely something you want to run by your legal counsel before you proceed. because technically you are acting despite the fact that you've got a conflict of interest. It's just under the commission's precedent. We're saying in these certain contexts, it's okay. Also, a couple other exceptions, lawful payment of salaries, employment benefits, those things are always permitted. Same thing with modification of county and local ordinances. And then lastly, I want to emphasize the fact that the conflict of interest laws do require some sort of direct and demonstrable benefit to create a conflict. Speculative or remote conflicts are not things that typically trigger conflicts. So, we see sometimes complaints of individuals, that an official took a particular action, and while it doesn't directly benefit them today, it could benefit them at some point down the line in the future. In those situations, we've said that there is no conflict of interest and the person was legally permitted to participate in the event or the action. It's still something you want to be cautious about, though. You can certainly still recuse if you wish. You may want to consider the appearance of impropriety, even though the law may not require you to step aside. It could be a situation where you just want to be cautious. And again, you want to consider these conflicts of interest ahead of any particular meeting. So make sure you are reading your meeting notices, your agendas, your materials ahead of time, so you can look for those potential conflicts and discuss with your legal counsel before you participate. And then the last thing I just wanted to briefly mention is the statement of economic interest. This is an annual requirement. It requires you to disclose certain financial interests that you have, where your income is, where your debts are, who are your creditors, that sort of thing. One thing, it's not really new anymore, but I do want to highlight is that you no longer need to disclose defined benefit retirement plans, annuities, money market funds, mutual funds. These things were excluded by the legislature from the definition of security, and so they don't need to be reported. Also, something else that we still see is a little bit of a problem is people not filing their final SEI. So this is an annual requirement, typically filed around mid-year, April. So you'll file it on an annual basis while you're serving. However, if you ever leave state service, you are required to file one last SEI within 21 days of leaving your position. So if you're leaving your position on a commission or council, make sure you do get that last SEI in before you leave. So with that, if there's any questions, I'd be happy to answer them. Otherwise, thank you very much for your attention today. I do appreciate the opportunity.
Thanks, David. That was a lot of information, but very valuable for our board members. A lot of times, our board members are cautious of any request that they get or any activity want to do, which is always great. Recently, we've had some board members reach out about engaging politically, not on their own, not as members of the board, but say wanting to go to a political fundraiser, wanting to put a sign for a politician they support in their yard, that sort of activity. Do you have any feedback for our board members on that sort of political engagement?
Sure. Yeah. I mean, obviously, everyone has their First Amendment right. If they want to participate in the political sphere, that's their right. But you do want to be cautious about how it's going to be perceived. We've got that issue at the commission as well. We're required to be nonpartisan, but obviously our governing board, they're all political appointees. They're going to be advocating for people that they agree with politically. But you want to be careful about how it's going to be perceived and how it could impact the work of the agency. So if it's a matter that you think could have an impact on the agency, that's probably something where you're going to want to steer clear, because that potentially is going to make the job of the agency harder, make it difficult to accomplish your own missions. But generally speaking, yeah, you still have that right of free speech, but I do encourage you to check with your agency counsel if there is a concern about potentially having an impact on the larger mission of the agency.
Great. One other question I have before we finalize today is a lot of times our board members, because of their professional expertise, they will get asked if they can present at a conference or present to an organization on a certain topic, either if it's about the board or about their professional area. And sometimes because of these organizations are very, they're professionally organized, so they could have a lobbying arm. What would be your advice for those types of situations?
Reach out to your agent's counsel or the commission as soon as possible. I get a number of requests just along those lines, like I've got an event coming up, it's coming up on Friday, and you're reaching out on Thursday. So try to give us a little bit more lead time, but yeah, generally speaking, there are exceptions that would cover those sorts of events. Even when you're addressing a lobbyist or a lobbying principal, there's an honorarium exception within there that would allow you to accept again the actual and reasonable expenses to go and talk to those organizations. So there's usually a way to do it, but it's important that you reach out ahead of time so that we can explain to you how to structure your involvement in a way that would allow you to accept.
Okay. And then we did get one question in the chat or in the question and answered feature. You stated that compensation over 1,000 needed to be reported for work in educational institutions. Is that $1,000 different from typical compensation rates or 1,000 even if within typical rates of reimbursement?
I'm not sure I completely understand the difference between those two, but it's $1,000. If you've received $1,000 in a calendar year, it needs to be disclosed as a source of income. So it's not meant to capture $1,000 more than a standard rate. It's $1,000 total. I don't know if maybe that maybe applies differently if you're talking like, there are clients maybe that offer like a standard rate versus a special rate or something like that. But yeah, that's something you might want to follow up on in more detail later.
Sure. Yep. And of course, anyone on this call that has additional questions, we have the contact information for our presenter today in the chat, but also you can reach out to your board counsel and we can address issues or refer as needed. I want to thank again, David, for presenting today. All great information. So thank you again.
Thank you.